guilty, and the sentencing will be based on those counts. So the usual starting range for manslaughter is about 7 years, but you may have the judge looking at aggravating factors such as the prevalence of the crime in the society, the fact that the deceased was his wife with whom he has children, life is lost, may also be an aggravating factor that the shooting took place in their house, the time of the night, which was about 10:30 or thereabouts, we're told, and the fact that a licensed firearm was used to kill Melissa in her house. And all of those matters could be aggravating, and those aggravating factors will add years to the starting point. And then the mitigating factor now, if he has shown some remorse in the social inquiry report, some of that may come out, or if he has a good antecedent report, if the social inquiry report was favorable, if he pleaded guilty at the first relevant date. I don't think that one applies, but it was after the relevant date, but before the trial, whether he surrendered himself to custody, whether he handed over his licensed firearm, whether he has previous conviction, all of those can be considered mitigating circumstances, which will reduce where we got from aggravating. And then the learned judge, considering those, will then decide how many years is this particular individual to get. And remember, I discussed the issue of discount before. Yeah. And we will hear whether what the judge comes to in on this particular count of the manslaughter, whether it remains within this range of 3 to 15 years, or it is of such a nature that in this instance it goes out. Remember, if the sentence is unduly lenient, the DPP can appeal it. If it is manifestly excessive, the defendant can appeal it. We're standing by. The court comes to us in 12 minutes. I come to base now to get some more matters on the road here from UTech. I'm joined by Ashley Jade Grinnell from Smith Warner International Limited.
Yes.
How are you?
I'm okay. I'm okay. Good morning.
Good morning. Good to have you. But this Grinnell,
yes.
This is from the Grinnell School?
That is the same one. Yes, yes.
That's because this is not okay. This is not a very, very common name.
Not at all. Any Grinnell, you know, that's my relative.
Okay, good. So tell me about Smith Warner International Limited. What is that about?
Smith Warner International Limited is a coastal engineering firm. We are a regional body, but our home is in Jamaica. Started about 31 years ago.
Wow.
And it started with Dr. Smith and Philip Warner, who are great coastal engineers and pioneers for multiple generations. So that would have been maybe a generation before myself.
Yes.
And we look towards building resilient coastlines and protecting Jamaica's coastal communities. And most of our projects are centered around that, whether it is national based or private based. We try our best to provide resilience and to protect the coastline. And that's why we're here at the National Resilience Symposium.
So who employs your company to protect the coastal community?
So we have multiple clients. Yeah. So most of the times it could be the bigger funding agencies, whether IDB or something like that. And locally, agencies like the PIOJ, JSIF, they would call on us to help with projects.
Right. So, but how does a company help to protect the coastline? What can we do? I mean, apart from the Palisados, where I say that we brought individual rocks from St. Thomas, which is just one of the most beautiful places I've ever seen in Jamaica, that whole Palisados now. What else do you do to protect the coastline? And mangroves, I suppose?
Yes. Yeah. So it's very similar. When we talk about these structures, we call them armor structures. And if you think of a soldier putting on his armor and protecting himself, that is how we see the shorelines and the coast. Right. So we can provide multiple options, whether hard or soft. So when we say hard, we think of those rocks that you mentioned. But softer solutions are incorporating mangroves. We have a concept called living shorelines. where we
Ooh.
bring in yes,
Living
where we
shorelines.
living shorelines, where instead of just boulders, we can do a combination. We can improve habitat, and we try our best to increase or to leave the place better than how we found it. So not only do we want to just protect with stones, we can also bring in other aspects. For us, we even this week we were on a school tour to help to inform our future generations on how we can protect the coastline. And so it's things like that that we try our best to involve ourselves in, not only doing the work but telling people how we can build a better Jamaica
Right.
with all these possible impacts.
I think I've recently learned how sand is made. Yes, sand and the role of the parrotfish.
Oh yes,
Yeah, in making sand.
yes.
So if a beach front is eroded, is there any way in what you do you can help to regrow the beach?
Yes, that's a big part of what we do.
Yeah.
We can provide structures to protect the beaches. Sometimes that could look like building out an offshore breakwater, which would then in the future become more like a reef habitat. We are also involved with a lot of marine biologists who help us to not only place the structures, but also to ensure that we're not doing any harm to the environment. And we may also just look at the overall movement of sand and how we can better keep the sand in the places that we prefer.
Wow.
So it's very possible.
Right.
Yes.
So what about somewhere like Hillshire now, with all of the erosion and whatever, or the reclamation that is taking place there? If you were commissioned by whoever the appropriate commissioner is, what could your entity do to restore what we've lost at Hillshire?
Well, we have actually been engaged at Hillshire multiple times, and we know from all of our assessments that it is possible to bring Hillshire back to a better state. It would involve quite a bit of community investment, national investment, and that would be to bring the protective aspect of the reef that was there before, that has undergone some damage. It would be to bring that back. That could be one way, along with many other options. That could be reclamation of land, bringing in other sand. But the one that I think is one of the best options because of the environmental impact would be to look at building back up that reef that used to be there but has gone under a lot of duress. Yes.
Right.
So,
and the reef, tell me what the reef does.
So the reef structures are these hard, spiny things that really help to break wave energy.
Yeah.
So when you have a live, colorful reef, that reduces the amount of energy that makes it to the shores.
Yes.
And if you have less energy, then you have less loss of sand.
Right.
So with the reef, you tend to find more protected beaches. You tend to find a calmer beach experience.
Right.
So we like to have naturally occurring reefs, and if that's not happening, then we can build it back.
Right. And the reef is a growing thing.
It's a growing thing. Yes, a growing thing.
Right. So what is it made up of?
They're little like little spiny needles, if you will, that keep building out. They have different shapes and colors, but the main thing is that they're hard material that can keep increasing in height. Yes.
But just come to think about it, whatever we do, we mitigate. But when you think of climate change with the melting of the ice caps, at some point in time, we may very well just get such large mass of water that's just gonna come inshore anyway and reclaim portions of the land. No,
it is possible, but all hope is not lost.
Yes.
So we at Smith Warner, we try to incorporate climate change in all of our solutions. So whenever we design structures or whenever we think of our elevations, we would incorporate a component for sea level rise. We would look at the possibility of bigger storms, something as ferocious as a Melissa. We'd start to consider those things going forward, especially because climate change is no longer a concept anymore. It's real. We're seeing it every day.
Yes.
So we do incorporate those allocations in our designs just to ensure that we can be more resilient in the future.
Well, I thank you so much for talking with me. You have such beautiful skin.
Oh, thank you.
Listener, she's super, super young, beautiful, dark, beautiful skin that is just such radiance. Ashley Jade Grinnell from Smith Warner International. She said they've been here for over 30 years. doing coastal engineering. Thank you so much.
Thank you so much.
It's 4 minutes, 37 seconds to the Supreme Court. We're up on a break. Take the break and come back to us on the hotline.
Remember, update your status in a real life. Go HIV test today.
Just 15 minutes, say your status clear. Real long life, our story.
The time by the Ministry of Health and Wellness is
15 minutes before 12.
You're now listening to Emily Shields Talk with Substance on Hotline. Radio Jamaica, active for the good of our nation.
Three minutes, 50 seconds to the Supreme Court. Court 1, the Chief Justice's Court, will open up the courtroom on the YouTube page of the Jamaican Judiciary in Open Justice. Not for the first time, the Judiciary of Jamaica is opening sentencing hearing so that we can hear exactly what judges take into consideration when they impose sentences for all sorts of crimes. One of the last times that we were here with you was the sentencing of the Cocoa Peace murderer, an awful five murders, I believe, that rocked the nation some time ago. A young man who pleaded guilty to the five murders, and we were able to see the mind of the Honorable Mr. Justice Leighton Pusey as he presided at the sentencing hearing and the court was opened up. We saw too that Andre Blackman Bryan sentencing hearing. We had the chance to hear the sort of diatribe that he put out in his unsworn statement from the dock. Call it what you will. It's open justice on full display for the people of Jamaica and the world. A forward-looking judiciary in 2026 will let us know in 2 minutes and 19 seconds time why did the judge accept the plea of manslaughter from Jolyan Silvera. Will some of that come in the decision of the judge with all of the conversations that we have had? And also we will hear from the learned sentencing judge. Will he stay within the sentencing range, the usual range of between 3 to 15 years for a plea of manslaughter, within 20 to 25 for the illegal possession of firearm? Or will he, in this instance, find a reason to go outside the normal sentencing range, perhaps because any discount given may shock the public conscience? We do not know. We will find out in a minute and 15 seconds. You may recall that on the 3rd of February, when Mr. Silvera was repleaded in the gun court, on count 1 of the indictment, he pleaded not guilty to using a firearm to commit a felony, that is murder, but guilty to using firearm to commit manslaughter. According to him, on the 2nd of February 2026, where they provided a statement which was authored and signed by Mr. Silvera, handed to the prosecution. And in the statement, he says on the 9th of the 10th of November 2023, he and his wife had an argument which got physical. During the argument, he said she blamed him, as she always did, for the death of their young son. During the argument, she hurled expletives, he said, and made derogatory statements about his sister and mother, which he found to be provocative, and he snapped. That raised the defense of provocation, which the court accepted to the great chagrin of many people in Jamaica. Here we are now, sentencing. Let's go to courtroom 1, the Chief Justice's Court, the 6th of March, 2026. The timer has stopped counting down to the court. We are not yet seeing inside the courtroom, nor are we yet hearing anything. As soon as we hear something, we will allow you to do the same. But Silvera, based on this plea, which has been accepted, there have been people who've been calling for the verdict of manslaughter to be done, the verdict, the plea, provocation, defense to be done away with in Jamaica. Doesn't quite happen like that. The court, the judge, the courts makes it runs in singles. This particular defense is of decades standing, coming from many jurisdictions. It is not only to the benefit of men, but also to the benefit of women, where things done, things said, those things cause somebody to act in a way that's uncharacteristically the individuals. And based on that, a number of things are assessed, including the time at which this action was taken. Did the individual have a chance to cool down, but didn't use the cooling down period properly, or what? So the cases are quite nuanced about the whole application of this defense of provocation, which is only available on a charge of murder. So, hard cases make bad law. So those who are clamoring for us to do away with it in Jamaica, no. So the stream has now reverted to live stream will begin shortly. Please stand by. We are standing by, and I know so are you. So the statement from the office of the DPP, again, underlying the great public interest in this matter. It's quite unusual for even a statement to come from the office of the DPP within the context of a gag order of sorts imposed where matters are before the court. But there was such outrage that was expressed by members of the society that the office of the DPP felt compelled, and I think rightly so, to issue a statement on the developments up to the 5th of February, 2026, portions of which I'd been reading for you. So according to Jolyan Silvera, he said during that argument, which he said he had with Melissa Silvera on the night of the 10th of November 2023, she made a comment about their children, which he found to be the final straw. And at that point, he lost control, discharged his firearm in her direction. I pause here because it is my understanding that the children, they are still here in Jamaica. They still attend school. And I cannot imagine the absolute emotional horror, the mental trauma that they have to go through. They've lost their mother, and their father was charged with murder. And then their father pleaded guilty to manslaughter. So in one incident, they've been orphaned. In one incident, spare a thought for them. And this is why I tell you something, as much as all of the arguments have come about these in-camera hearings and the value of the open justice, you see in situations like these, some of what would come out from this case, if it was tried and reported, would probably lead to irreparable harm on top of irreparable harm for these children. We're waiting for the court to come back, but Jolyan Silvera, in that signed statement which his team provided to the prosecution, says it was not his intention to hurt or kill Melissa that night, and that having done so, he panicked and left the apartment. He stated over the course of the days following her death, he thought about his children losing both parents and thus made the decision to not admit to what he'd done. Bear in mind all of these matters which you may think were not considered when the defense of provocation was accepted and which reduced murder to manslaughter. They may be considered by the learned sentencing judge in the sentence. They may be considered aggravating factors. So nothing is lost, right? Nothing is lost. When all of that statement came from Jolyan Silvera, I see the Chief Justice. The platform has opened up to Courtroom 1. The Chief Justice's court is open. The Jamaican judiciary is ready. It's 4 minutes to midday. On the 6th of March, 2026, we stand by to hear what the Chief Justice will say in his assessment of all that is in front of him in the sentencing hearing of Jolyan Silvera, a former legislator, a man who occupied one of the highest lawmaking bodies in the country, the Parliament of Jamaica. Let's go over to the Supreme Court. The Chief Justice is about speaking now.
Of the King against Jolyan Silvera, charged on an indictment containing 2 counts. Count 1 charges him with the offense of using a firearm to commit a felony, contrary to Section 14.2 or Section 14 subsection 2 of the Firearms Prohibition, Restriction, and Regulation Act. The particulars of that offense are that Jolyan Silvera, between the night of November 10, 2023, and the morning of November 11, 2023, in the parish of St. Andrew, used a firearm to commit a felony. Initially, the felony was murder. It was changed to manslaughter, and he pleaded guilty to that offense. Count 2, charge him with the offense of murder. Particulars of that offense are that Jolyan Silvera, between the night of November 10, 2023, and the morning of November 11, 2023, in the parish of St. Andrew, murdered Melissa Silvera. To that count, he entered a plea of not guilty of murder, but guilty of manslaughter. The plea was accepted by the prosecution and accepted by the court. This plea was entered on February 3, 2026. And on that date, a statement from the defendant was read into the record. And it states, I, Jolyan Silvera, made this statement to say that on the night of November 10th, 2023, a very unfortunate incident occurred, resulting in the death of my wife, Melissa Walter Silvera. Leading up to that event, there has been provocation from her ever since the death of my son, for which she continues to blame me. As per usual, to avoid confrontation, These confrontations vary from financial to taking responsibility for the conditions that we were living in, and she has a time where she explodes no matter when and where. She became very physical that particular night. These are ongoing things. So at times, when I see that this is going to blow out of proportion, I normally take refuge, thank you, at my sister's house to allow her temper to quell. On this particular night, the rhetoric began. She became more confrontational than normal, screaming, shouting, and even at times swinging her fist. So I decided that it was time to leave. So I reached for my gun, where it is normally kept, to holster it, and told her that I would be back tomorrow. She became increasingly angered and enraged, and lunged after me and grabbed at the gun, and then uttered the words to the effect that I was responsible for the death of our child, and made derogatory comments about my mother and the family. Although she had mentioned blaming me for the death of my son before that night, the way she said it and how, and the mention of my mom and my other family, her words and expletives that night really angered me in the moment. Melissa told me I must stop fucking my sister. Bitch. And maybe I should go and fuck her.
Oh. Okay. Go ahead.
Evening. Now let us go now to what the prosecution outlined to the court. And then we'll have some observations about that, and then put this in context of the law. And then we'll have some observations about that, and then put this in context of the law relating to homicide. Prosecution's narrative is this. Sometime after 10:30 p.m. on the 10th of November 2023, Mr. Silvera told his wife and children that he was leaving and that he will return the following day. His wife told him that he could not leave, and an argument ensued. According to the children, the adults swore at each other and then he left. Sometime before 6 a.m. on the morning of the 11th of November 2023, one of the children, and the name is there, but I'm not calling the name, went into his parents' room. He discovered his mother's lifeless body on the floor next to her bed. He observed that blood was coming through the coat, her butt, mouth, and nose. He ran from the bedroom and alerted his other brother, who accompanied him back to the parents' room. They indicated they both checked for signs of life. They then decided to make contact with their father and were eventually successful. The prosecution next referred to a witness statement provided by Mr. Silvera. This is a statement that was provided before he became a suspect. In that statement, he indicated that upon speaking to his children, he contacted the Stony Hill police station and told them that he was on his way home when he got a call from his son indicating that his mother's lifeless body was there and that he needed assistance. Upon arrival at the house at 28 Diamond Road, Stony Hill in the parish of St. Andrew, Mr. Silvera went into his bedroom, saw his wife sitting in a position with her head leaning forward at the side of the bed. According to witnesses, that is the children who were there, he touched her, spoke to her, and found that she was not responding. So up to that point, based upon this, you had the body, the children, then Mr. Silvera arriving, then you had Mr. Silvera, the body, and the children. Short while after, a first responder from the Jamaica Constabulary Force arrived, that is a sergeant from the Stony Hill Police Station. He went into the bedroom along with Mr. Silvera, where he, the police officer, saw the body of the deceased. The police officer described the body as being on her knees in a crouching position with her face lying on the floor. The police officer then took a photograph of the body, and whilst he did so, he says Mr. Silvera cried out. He told Mr. Silvera to cover the nude section of his wife's body. The police officer did not carry out any further examination of the body. The officer indicates that he did not, that Mr. Silvera advised him that the deceased had no known medical condition, and the police officer seems to be indicating that a post-mortem examination would be conducted to determine the cause of death. The House of Tranquility Funeral Home was contacted for the removal of the deceased body. Not clear from the narrative who did the contacting, but nonetheless, that was a contact that was made. The police officer says he then indicated that he told Mr. Silvera, do not do anything to the bedroom pending the post-mortem examination, as the cause of death was undetermined. Mrs. Silvera's body was removed and taken to the House of Tranquility Funeral Home. A post-mortem examination was scheduled for the 1st of December 2023. The pathologist who arrived to do the post-mortem examination observed marks on the body. As a result of her observation, the body was sealed and the detectives were called to assist in the investigation. So, on the 15th of December 2023, the same pathologist conducted post-mortem examination on the body of Mrs. Silvera. The pathologist noted that there were 3 gunshot wounds, 1 perforating gunshot wound to the front right thigh, 1 penetrating gunshot wound to the left side of the lower abdomen, and the 3rd that is described as a superficial penetrating gunshot wound to the right side of the lower abdomen. The pathologist found that the immediate cause of death was due to multiple gunshot wounds. During the post-mortem, the pathologist removed 2 projectiles from the body of Mrs. Silvera. These projectiles were handed over to an officer, not the one who turned up apparently on the 10th of November, assigned to the Jamaica Constabulary Force. And it was after the post-mortem was concluded, Mr. Silvera became a suspect and was taken into custody. The narrative goes on to indicate that he's a licensed firearm holder. Specifically, he has a 9mm Glock Model 17 Gen 4 double action auto-loading pistol black polymer receiver slide, a 17 cartridge capacity magazine bearing the serial number AAFZ038, and this firearm was taken from him. The firearm was submitted to the Institute of Forensic Science and Legal Medicine for ballistic testing, along with the 2 projectiles removed from the body of the deceased. The ballistic examiner made a comparison. He test fired the gun. This is now in January of 2024. Test fired the gun. He took results from those test fires of January 2024 and compared it to the projectiles that were removed from the deceased body. He found what he called level 1 characteristics matching. That is, according to the narrative, The projectile came from a Glock pistol, the type of Glock that it would have come from. He found that there was some amount of level 2 matching, and this apparently is striations, and that there were no additional markings that were unusual. So I'll pause here for a moment and indicate this. In preparing for this matter, I was reading through the material, and I had sent questions to both counsel for the Crown and the defense through the registrar of the Supreme Court to answer specific questions. I had used the incorrect expression. I think I used markings, level 1 markings are not matching. So counsel for the defense, being the cautious man that he is, he indicated that he did not have any document that referred to level 1 or level 2 markings. So that was my error. They should have been matching. The Crown also responded, getting assistance from Superintendent of Police Miguel Bernard, and he responded, and apparently this is a quotation from him. I don't think the defense is taking issue with the exposition on this by the superintendent. He says, correcting me, that the term used was level 1 matching and level 2 matching. The term is used to provide a simplified understanding of the examination process. Level 1 matching, this is matching of the class characteristics. Class characteristics can be used to eliminate certain firearms as potential sources of firing a bullet or a cartridge case. However, they do not narrow it down to one specific firearm in the class or group. Class characteristics of bullets include the caliber, the number of lands and grooves, direction of twist of lands and grooves, and width of the lands and grooves. It says in this case of the King against Jolyan Silvera, the class characteristics narrowed the source of the marks on the bullet to Glock pistols, which is a smaller group from all the potential make of firearms that exist. The accused firearm submitted as evidence in the case was a Glock pistol. Therefore, the examination progressed to level 2 examination. So what he seems to be saying is that the level 1 determines the class. And then once it falls, identify the class, then you go on now to see about the specifics of the object, the gun. Level 2 matching, he says, is this. This is matching of the individual characteristics that are unique to one specific firearm. At this level, the comparison requires microscopic analysis and cannot be done with the naked eye. Individual characteristics of bullets are random, striated marks, striations on the land impressions on the bullets. In this case, the King against Jolyan Silvera, there was sufficient matching of the individual characteristics to conclude that the bullets matched the test fires said to be from the accused's licensed firearm. He says the damage seen in the barrel was consistent with a corrosive chemical reaction in the barrel, was unlikely to have occurred naturally because in the relatively short space of time between the death of the deceased Melissa Silvera and the gun being submitted to the ballistics department, this corrosion distorted the individual characteristics, making it difficult to match bullets fired through the barrel before the corrosion and those that were fired through the barrel after the corrosion. That is to say, the damage was consistent with or likely a deliberate attempt to prevent any subsequent matching of test fires from the gun with any bullets that were fired through the barrel prior to the corrosion. So we go back now to the narrative here. Yes, so he continues now. There is something called an IBIS system, that is an integrated ballistic identification system, commonly known as IBIS. This is a database, and this database contains firearm ballistic signatures. So how does this come about? Under the Firearm Prohibition, Restriction and Regulation Act that came into effect in 2022, roughly a year before this incident, Section 20 of the legislation sets out the responsibilities of what is called the Firearm Licensing Authority. Section 20, subsection 1 says, there shall be established for the purposes of this act a body to be known as the Firearm Licensing Authority, which shall be a body corporate to which Section 28 of the Interpretation Act applies. Section 20, subsection 3 states, the authority shall be responsible for regulating, in accordance with this act, the handling of firearms and ammunition, and the importation and exportation of firearms and ammunition into or from Jamaica, and without prejudice to the generality of the foregoing, the functions of the authority shall include, and it has an impressively long list, but for our purposes now, we come to paragraph L, which says that that is the Firearm Licensing Authority to conduct ballistic testing, capturing ballistic signatures, in relation to privately owned firearms and capturing related information with respect to firearms that are the subject of authorizations granted by the board. Then there is reference to Section 29, which speaks to the identification of firearms. And then there is Section 31, which says the institute shall be the responsible entity for capturing ballistic signatures and other information in relation to firearms that are the property of the government of Jamaica. And then Section 31, subsection 2 says the authority shall be the responsible entity for capturing ballistic signatures and other information relating to privately